Good evening. I hope you all had a nice tea. Thank you very much for being here this evening for this evening session. As you know, today we are trying to bring together a mock trial for a patent infringement suit in India. The intention of today's mock is to achieve a couple of things. Number one is to give you a demo and experience of what goes on in a patent infringement suit in this country. Of course, while a live case can take anywhere from months to years depending on the fora it is at, the idea today, this evening, is to capture some key proceedings and some key important issues that are critical during the course of a patent infringement suit in this country. What we will also look at this evening is the strategies and the decision making that goes on at patentee's end before or while they decide to institute a suit for infringement. Of course, they also need to be mindful of the fact that they can be countered and challenged at any stage of the suit. So this trial will also look at their preparedness for that. Coming quickly to the subject matter of today's mock trial, and as you could see, you have some handouts on your tables. We also have kept the demo pieces on the center table there, as well as a cutout demo right here. So very briefly describing the subject matter of today's trial that we're looking at. The patentee's product is a tissue box which has the centerpiece as the dispensing unit, which has a certain shape to it and is made up of thermoplastic material. On the other hand, the alleged infringer or the defendant here has a similar looking tissue box but with a slightly different dispensing unit. So today's trial will basically look at the fact as to whether the defendant's product, the allegedly infringing product, is infringing on patentee's product, which is covered by the independent claim of the patent. I would also like to mention here that the patentee in today's trial, or the plaintiff, is a large-sized multinational corporation, whereas the defendant or the allegedly infringing side is a local homegrown company based out of Chennai. This mock of today will be brought to you by our team at K&S. Just quickly introducing them to you. The plaintiff or the patentee will be represented by Mr. R. Shivkumar.
Hi.
He will represent the company as an inventor and director. His counsel will be played by Mr. Saurabh Anand.
Good evening, everyone.
The defendant or the alleged infringer will be Mr. Ravi Bhola.
Hi.
And his counsel will be Ms. Namrata Chadda. The honorable judge, both at the district court and high court level, will be Mr. Satyam Rathore.
Hello, good evening.
And I, Durgesh Mukhaya, will be your narrator for the evening and will also play a short role of local commissioner during the cross-examination proceedings. So without much ado, let's directly jump into this. Let's start the proceedings today by hearing out the director or the inventor of this patent, and let's listen in to something that has caused him some concern. Over to you.
Hello, everyone. Myself, Shiv Kumar. I represent Tizen Inc. Tizen Inc. Is one of the well-known leading companies in the segment of consumer care products. So a range of products we manufacture and we sell across the globe. One such product which is very important for us is called Cleanse, which is a box of tissues, and that is covered by way of patent IN 123456, which I think you will come across in some time. So we have been selling this product both online and offline since 2008, and the sales of this product has exponentially increased since 2008, since when we started marketing the product. So when I say exponentially increased, in turn the revenue generation also has increased. However, what we have seen is a dip in sales in 2017. So a statistics which shows that sales from 2008 to 2017. So dip in sales, marketing team got into the picture. They made some investigation and they figured out that the dip in sales of our product, Cleanse, is because of the identical product which is also sold in the market by Ville Private Limited called Wipes. So based on the statistics of 2016, we also projected the figure for next 5 years. But this 2017, the picture of the sales of 2017 came across as a shock for us. So that is when we got involved, our counsel, Mr. Saurabh Anand, who also has collected some information from legal perspective. Saurabh, can we discuss about that?
Good evening, everyone.
Yeah, it is.
Hi, Shiv.
Hi.
Good evening, everyone. We have been thoroughly briefed by your team regarding the sale of the allegedly infringing products.
Right.
That is wipes by one of the allegedly infringers, Wiley Private Limited, based out in Chennai. Based upon the information provided, we have also procured information from the Ministry of Corporate Affairs, and these are the certificate of incorporation, if you can just see.
Yeah.
Suggests that they were recently been incorporated in November 2016. After that, with a bare minimal capital of INR 5 lakhs.
Okay.
However, this also suggests that they don't have any further branch offices other than Chennai. Going ahead, we also sought help from other legislations like Right to Information Act, and you'll be shocked to know that they are not only manufacturing within the jurisdiction of India, but also they are exporting.
Oh.
If you can just see the replies what we have received from the customs
Okay.
authorities,
Okay.
it suggests that in 2018 January they have exported in US, Singapore, China,
Right.
where I believe we have a pretty decent market.
Yes, we do have across the globe.
Exactly. We further dig down and file the RTI information to Ministry of Environment and Forest Science. Basically, before incorporating any company, you would require certain kinds of clearance from certain ministries, and since this is a chemical industry, so
Right.
it sought clearance for disposal of certain different kinds of materials. It was shocked to know that in October 2016, that is just 1 month before the incorporation, they got this clearance.
Okay.
Going further, we also sought an on-ground investigation, and we procured the products, and as we are already aware.
Yes, our team was in the picture to get it tested. Yes.
Exactly. We got the product tested in-house lab, and what the lab suggested that the infringing product or the allegedly infringing product, wipes, squarely falls within the scope of the granted patent. That is 1, 2, 3, 4, 5, 6.
That's a good thing. Good news for us at least. Yeah.
Exactly. So as we discussed, we have also sought an expert opinion from the professor of Institute of Packaging, Dr. Khat, and he is also of the same opinion that this product wipes clearly falls within the scope of suit patent.
Saurabh, I'm a technical person.
Yes.
And I cannot produce the affidavit.
Definitely, you are not only a technical person but also the inventor of the same.
Yes.
But
That's
in
what.
courts, prima facie, it is advisable to proceed with a neutral third-party expert,
Okay.
just to remove certain kind of prejudice within the judge that since this is an in-house expert, it might be biased towards the plaintiff company. That is the only reason we suggest that we should move ahead with certain neutral experts who would backing our in-house studies.
Okay.
So that's how we are right now on the ground reality.
Right.
So in this scenario, considering the loss in sales, what we have incurred in 2018 as well as projected losses,
Yes.
the best course of action, what we could suggest, is filing a suit for patent infringement.
Wait, I thought we should start with legal notice.
Legal notice will definitely your in-house legal counsel must have briefed about it, but there are certain repercussions involved to it. Once we should have legal notice, they will come across that we might be filing a suit against it. Meaning thereby, they might file a caveat petition.
Okay.
The petition is, they will file a petition before the court so that any suit or any order should not be passed without giving a prior notice to them. In these circumstances, the first injunction, that is called ex parte ad interim injunction, that meaning thereby, in the absence of the infringer, there are possibilities we might lose that opportunity.
Okay. So, I mean, I'll go with your advice. You are the best person to judge as to what is the further course of action we need to take.
Definitely.
So, let's go ahead with the filing of the suit. And let me know what other.
I would advise you 3 things over here.
Yeah.
We have to maintain as much as confidentiality we can till the filing of the first suit. Since this is a grey market area because the tissue box is available not only online but also offline. there are possibilities the news might go in the market.
I understand.
Yep.
So, I mean, I assure absolute confidentiality. You prepare whatever documents is required,
Very well.
are required, and we can go ahead with
And
that.
we'll be filing the suit in Bangalore, considering we are based on US, but we have marketing team here.
Right.
And now we are procuring the infringing product from the jurisdiction of Bangalore, although they are situated in Chennai. But both the courts in Chennai, as well as all other courts
Okay.
where the infringing products are available, will be having jurisdiction to try to
So, wait, wouldn't that be a problem? They are located in Chennai, we are in Bangalore.
laws have matured enough to suggest that suit can be filed firstly where the defendant have been incorporated or voluntarily gained the voluntary worth or gain of business, as well as for wherever the infringing products are available.
Okay.
And plus we have a commercial courts in Bangalore. That means you will get a speedy trial, and Bangalore particularly we have an IP designated bench as well. So
Okay.
in all likelihood I would suggest to go with proceeding suit infringement in Bangalore, considering all these probabilities.
All right. Then we'll go ahead with filing the suit in Bangalore. We'll see how it
Very
proceeds.
well.
Yeah.
Let's draft the draft
Sure.
and share it off with you.
Sure. Thank you.
Thanks a lot, sir.
Thank you.
So patentee and their counsel, they have now decided to institute a suit for patent infringement at an appropriate forum, which in this case is Bangalore District Court, because the cause of action arose in Bangalore. So we will straight away take you to Bangalore District Court, where the patentee's counsel is making his submission.
Thank you. My Lordship, patent bearing number OX 45678.
Of 2019, is a suit for patent infringement. My Lordship will straight away go ahead to document number 2, which is a legal proceeding certificate as procured from the Indian Patent Office. This is just to substantiate the fact the patent in question, that is 123456, is valid and subsisting till date. My Lordship, over document number D3 and D4, we have established that the plaintiff, Tyson Inc., is a multinational company based on US, as well as the product in question is Cleanse. We have already produced a couple of brochures. If you can, my Lordship can just see document 4 and 5 for that. My Lordship will straight away go ahead with document number 5, which is nothing but an independent CA certificate substantiating a loss in sale of this particular product in question, that is Cleanse. If you can just refer to that figures, my Lordship, it suggests that somewhere in middle of 17, the dip has been started and still been continuing, and we have also projected a loss in sale of this particular product in the next quarter. My Lordship, we've launched ongoing investigation and came across this particular defendant company, which has been named a defendant in this particular suit, Ville Private Limited. They got incorporated in November 2016. My Lordship, we have produced a certificate of incorporation as document number 8. Our in-house reports, as well as our sales marketing team, has procured the infringing products. My Lordship, the infringing products are right in front of you. These are the infringing products, and these are our product in question, Cleanse. Our sales team and marketing team has procured these products via 2 means, online as well as offline means. My Lordship, you just turn to page number document number 13. We have produced original invoices of procurement of these particular products within the jurisdiction of this honorable court. At document 14 over the page, my Lordship, an invoice from Amazon.com, which has been delivered within the jurisdiction of this honorable court, has been submitted, establishing thereby this court has jurisdiction to try the present suit. My Lordship, we procured these products and launched our in-house ongoing investigation and sent these products to our in-house labs, and at document number 14 we have produced in-house reports which suggest that the characteristic feature of these particular infringing product as produced right in front of you, my Lordship, squarely falls within the scope of our granted patent 123456. My Lordship, in addition to that, we have also sent these products to an independent expert and he's a professor from Institute of Packaging, Dr. Bhatt, and he has sworn an affidavit, which has been produced, document number 15, to substantiate this fact that the infringing product squarely falls within the scope of the suit patent. My Lordship, we have also received replies from various authorities like Customs, which suggest that they are not only manufacturing but also exporting. Replies from Ministry of Environment and Foreign Sciences, which suggests that they sought clearance for incorporating this company just 1 month before the incorporation, that is October 16. And they got incorporated November 16. My Lordship, with all due respect, we have thoroughly established the prima facie case of infringement by virtue of in-house reports as well as an independent lab report. Irreparable harm can be further substantiated by the continued loss which we are incurring because of the presence of this infringing product in the market. And as per the projected figure, this loss might further occur. In all humble submission, my Lordship, the balance of convenience lies in the favor of plaintiff, and this is a perfect case for the grant of ad interim ex parte injunction without any delay. That's all from my Lordship.
I've heard the plaintiff on IA number 1. On a perusal of all the materials placed on record, I am satisfied that the plaintiff has made out a prima facie case for the grant of interim injunction. I base my satisfaction on the following factual position. Infringing products are available within the jurisdiction of this court. Affidavit of the neutral expert as provided by the plaintiff, which this court is empowered to take into consideration under section 115 of the Patents Act 1970. The patent number 123456 is valid and subsisting. I am further satisfied that this is a fit case for grant of ad interim ex parte injunction, as the certified sale figures produced by the plaintiff showcases continuing loss suffered by it due to the presence of infringing products in the market. If injunction is not granted at this stage, the plaintiff is bound to suffer irreparable injury which could not be compensated with monetary damages. Therefore, in the balance of convenience also lies in favor of the plaintiff. Hence, I proceed in passing of the following order. Pass an ex parte ad interim injunction as prayed for in IA number 1, which shall be in force until 18th of February 2019. The plaintiff to proceed for compliance, defendant to file written statement and other objection by 18th of February 2019. Please, my Lord.
As an ex parte ad interim injunction order restraining the defendant from carrying out any further activity pertaining to their allegedly infringing tissue box. The court has also given the next date of hearing where the defendant's counsel will make her submissions. Let's listen in.
I represent the defendant company Ville Private Limited, and the suit has been filed by the plaintiff for infringement of IN patent 123456. My Lordship, we have filed our application for vacation of ex parte injunction, and we challenge the patent as it ought to be revoked for the reasons stated in the written submission. My Lordship, before we move to the revocation challenge, we would like to iterate certain preliminary grounds. My Lordship, my client Ville Private Limited is a reputed company based out of Chennai and has no office in Bangalore or any other part of India. My Lordship, they sell their products online as well as through market channels. Further, they do not have any commercial nexus within the jurisdiction of Bangalore. My Lordship, a meager online sale through online means within the jurisdiction of Bangalore does not give jurisdiction to this honorable court to try the present suit. My Lordship, meaning thereby that the online sale gives a jurisdiction means each and every online sale from my client means that he is vulnerable to be sued in each and every court of India. This was never the intention of the legislature. My Lordship, we rely on our written submission on plethora of judgments wherein it's been clearly identified by courts time and again that there should be a substantial cause of action. The two invoices submitted by the plaintiff have merely been made out to show that there is cause of action. My Lordship, as there is no cause of action within the jurisdiction of this honorable court, this suit is not maintainable and the plaint should be outrightly rejected. My Lordship, Coming to the ex parte injunction, we have not been given any opportunity whatsoever to present our case. My Lordship, in patent cases being very complex in nature, it has been time and again highlighted by courts that the defendant should be given an opportunity to present their case. My Lordship, there are several material facts which have been concealed from this honorable court to get the injunction. The injunction has been obtained on a misrepresentation that my client's product, Wipes, is infringing the suit patent IN 123456. My Lordship, this suit patent relates to a tissue box comprising 4 dispensing tongues made out of polyethylene material, whereas my client's product consists of 2 rectangular dispensing tongues and made out of nylon. My Lordship, please have a look at the products again. The 2 rectangular dispensing tongues are very different from the 4 oval dispensing tongues made out of polyethylene. Further, my Lordship, this nylon has neither been claimed or enabled in the suit patent. My Lordship, the export affidavit relied upon by the plaintiff is nothing but a duplication of their own in-house report, which means that the credibility of the person giving the report is seriously compromised. My Lordship, without prejudice to the objections on the jurisdiction and lack of cause of action, the defendant is also challenging the validity of this patent as it ought to be revoked for the reasons stated. My Lordship, thus, in my humble submission, this plaint should be outrightly rejected with heavy costs on the plaintiff to discourage misuse of law. In the alternative, the ex parte injunction granted on 19th of January should be vacated for the reasons as submitted. My Lordship, we have also relied on numerous judgments in our written statement which clearly substantiate that once the patent's validity is challenged, there is no prima facie validity attached to it, and thus injunction should be vacated. Further, my Lordship, we undertake to provide accounts of profit. Now, since there is no prima facie validity attached to the patent, and we undertake to provide accounts of profit, the balance of convenience does not lie in the plaintiff's favor. Thus, in our respectful submission, my Lordship, it is a fit case for rejection of the plaint as well as vacation of the ex parte injunction. That's all from my side, my Lordship.
My Lordship, my learned friend has challenged our suit on a couple of grounds to be numbered as 6. The first is jurisdiction. My Lordship, the terms used by my learned friend is meager sale. My Lordship, with all due humble submission, the invoices submitted before this honorable court are just a representation to substantiate that they have substantial commercial nexus within the jurisdiction of this honorable court. Thus, the fallacious use of the word called meager will not discharge the burden that although they incorporate their company in Chennai, but they are not available, their products are not available within other parts of the country. My Lordship, I would like to place reliance on a recent judgment of Supreme Court as well as upheld by Delhi Division Bench High Court, which suggests that procurement of infringing products by an online means will give a jurisdiction to that particular court to try that suit. Coming next, my Lordship, the intention of legislature was being tried to be explained by learned friend. My Lordship, that legislature enacted 1908, and we all know that precedents keep on changing. My Lordship, again, we would like to place on record the Division Bench judgment by Delhi High Court, which suggests in a matter like this, it's a mixed question of fact and law. That's why at the interim stage, it cannot be decided till the trial is over. My Lordship, second contention regarding ex parte injunction in patent infringement cases. My Lordship, that those are old days. Now from 2015 onwards, we have seen plethora of orders wherever the moment an ex parte injunction is granted by the various high courts, including Delhi High Court, Kolkata High Court, Bangalore District Court, from everywhere, my Lordship. The only 3 things have to be proved here. Prima facie case of infringement, which we have already done. balance of convenience and irreparable harm. My Lordship, coming to the another contention of material facts have been conceded. My Lordship, I must say this is the first time I have ever heard in the patent infringement suit that the products are being compared, where the law is very straight, my Lordship. It has to be compared with the granted claims with the infringing products. A fallacious approach has been adopted by showing this court our product, which is very well covered with the suit patent, as well as infringing product, where the law is very clear. It has to be between granted claims and infringing product. And for that very reason, my Lordship, we have already submitted our in-house reports as well as expert witness report from an independent lab. My Lordship, coming back to the discharge of burden, we have sufficiently discharged burden by substantiating this report of prima facie case of infringement. On the contrary, my learned friend is trying to play around with the wordings used in the claim and trying to suggest that nylon has not been claimed in the granted patent. My Lordship, all these are matters of trial and cannot be decided at this point of time. My Lordship, they have not submitted any report to substantiate that they are not at all infringing. Whereas on the other hand, we have submitted the reports discharging our burden, not only from in-house report as well as from an expert affidavit also, to substantiate the prima facie case of infringement. Nothing has been replied by my learned friend regarding RTI replies which we have received regarding custom authorities as well as their incorporation or after getting certificate from Ministry of Environment and Forest Sciences. Coming to the undertaking given by them regarding accounts of profit, my Lordship, our prayer is limited to injunction. That's it. Section 10 of the Patents Act gives me ample opportunity to choose my right what I want. In the humble submission, my Lordship, this is a fit case where ex parte ad interim injunction granted by this Honorable Court on 18th of January 2019 should be made interim till the disposal of this particular suit and matter should proceed for trial. That's all from my Lordship.
Defendants have filed their written statement, application for rejection of the plaint, and counterclaim challenging the validity of the suit patent number 123456. The defendants have also filed their objection to IA number 1, seeking vacation of the ex parte ad interim order as granted by this court on 19th of January 2019. I have heard both the plaintiff and the defendants. I have gone through the defendant's application for the vacation of the ex parte ad interim order passed by this court on 19th of January 2019. At this stage, the defendant has failed to present any compelling ground in their application for the vacation of the said order. Therefore, the application filed by the defendant for vacation of the order dated 19th of January 2019 stands dismissed. I am further of the view that as the defendant has filed a counterclaim challenging the validity of the suit patent, I order the transfer of the suit to the Honorable High Court. Further, question regarding the rejection of the plaint is a matter of trial and the same is therefore kept pending. Therefore, I proceed in passing of the following orders. The suit stands transferred to the Honorable High Court. The ex parte ad interim order as granted on 19th of January 2019 shall remain in force. Application for rejection of the plaint is kept in abeyance.
Please, my Lordship.
So as at this stage, because the patent was also counter-challenged by the defendant, as per the Patents Act, the entire suit now stands transferred to the High Court. In this case, the appropriate High Court is the Karnataka High Court, where the High Court has gone on to frame some issues. We will take you to the proceedings of the High Court, but at this stage, if there are any questions, we'll be happy to take them.
I'd like to point out that only before 1 month of the incorporation they got the statutory clearance. What was the logic you incorporated those statements? Okay. It has nothing to do with the infringement trial.
No. There's nothing to do with the infringement trial. What we are trying to suggest how you can utilize couple of alternative legislations to understand the intention of particular company. So these are just mock things which we generally do in our general practice. For example, if it is a pharmaceutical case, if any generic company is coming and we sought RTI replies from, say, drug controllers to get whether they have got any manufacturing license or not. It operates in different fora. So here what we're trying to suggest that this is a particular company which deals in a particular kind of chemicals And for that, you need certain kind of environmental clearance before incorporating that particular company. That's why the months are very important here. They got clearance in October 16, and company got incorporated only after getting that clearance, that is November 16. So that was we're trying to substantiate how the company and intention behind it. And further, the intention of the company will be further be clarified during the cross-examination when we will be cross-examining the witness of the infringer.
And you showed the downward trend of the profit line. So is that the only argument that is sufficient, or because you said that that monetary loss could not be even recovered through monetary compensation?
Yeah.
But let's say if there was a monetary compensation, that would have sufficed, right? So
Okay.
is that a valid ground for irreparable loss?
Yeah, very well. So in case of interim injunction, you have to substantiate 3 points. Prima facie case of infringement, irreparable harm, as well as balance of convenience. If the monetary terms, what you suggested, can be quantified by term of money, there is no interim injunction should be granted. So that's the concept. Here comes when we claim that I want, say, 5 crore damages, meaning thereby I have calculated my losses. That can be quantified, so interim injunction should not be granted. There are 2 types.
Okay, we will take further questions at the end of the trial. Moving on. So, as I said, the trial now, the suit now stands transferred to the High Court, and the High Court has framed the following issues for further consideration. Number 1, whether this court has the jurisdiction to entertain the suit, whether the plaintiff is the proprietor of the patent in question, whether the patent number 123456 is valid, whether the defendants have been infringing the patent in question, and damages, if any, that need to be awarded with respect to either of the parties. We will now take you to the High Court, and we will now take you to the proceedings called cross-examination. Cross-examination is an important proceeding during a patent infringement suit where both the parties are trying to establish valid grounds on their side. I have been appointed by the High Court, by the Honorable High Court, as the local commissioner to oversee the cross-examination proceedings. So I will take my chair there, and then we will witness the cross-examination. This being a commercial court, they have also framed case management hearing timelines. So basically, the entire suit needs to be concluded within a set time frame, and that's what has been decided by the court. We will now begin the cross-examination proceedings with the Defendants Counsel cross-examining the plaintiff.
Good evening, Dr. Shivakumar.
Good evening.
Can you identify signature in this affidavit?
Well, it's me who has signed the affidavit in all the pages as a deponent.
Very well. Who drafted this affidavit?
I have drafted in consultation with my legal counsel.
Okay, so you're saying that your legal counsel helped you to draft it. I assume he also got it notarized for you.
No. I was present before the notary.
All right.
You see?
So you say that you are one of the inventors of IN 123456. Who are the other inventors?
Jeff and Muller.
So what exactly was your contribution to this patent?
You see, I was an integral part of the core team in conceiving and developing the invention.
That does not answer my question, Dr. Shiva. What exactly was your contribution in this patent?
I guess that answered your question when I meant an integral part of the core team.
Very well, let's move on. Dr. Shiva, you say in paragraph 7 of your affidavit that you were the co-lead of the project team who developed your product, CLINS.
Yes.
Could you name the other lead?
Mr. Robert. He is from Mechanical Designs Department.
But he is not reflected as one of the inventors in the suit patent.
No, he joined us after the filing of the suit patent, and he was only involved in the product development.
So as you are one of the inventors and Mr. Robert is not an inventor of the suit patent, I put it to you that the suit patent does not cover your product, CLINS.
My Lordship, we have an objection to this question. This is based on legal presumption, should not be allowed.
The admissibility of this question will be decided by the Honorable High Court. For timing, I'll let the witness answer.
Please, my Lordship.
Okay, in my opinion and experience, the product claims our product is very well covered within the suit patent.
Are you aware of the Patents Act?
Yes, although I am aware, I am not qualified to practice Indian laws.
In which jurisdiction are you qualified to practice law?
None?
And were you involved in any patent litigation before this?
No.
So I put it to you, Dr. Shivakumar, that you have no knowledge of patents law and you cannot interpret a patent document.
By virtue of my educational qualification and experience, I am generally aware of the basics of patents. And if you see, I have 10 patents to my credit.
Very well. So you are saying that you are well aware of the concepts of novelty and obviousness.
Yes, as stated earlier, based on my knowledge of patents, I have basic knowledge of patents.
In that case, Dr. Shivakumar, kindly refer to the suit patent. And let me know if this patent, the tissue box claimed in this patent was novel on the date of priority, namely 16 November 2004.
See, in my opinion, it was novel at the time of filing of the application, which is the priority date.
Alright, then in that case, kindly point out the novel features.
Novel features lies in the fact that the dispensing material is made of thermoplastic, and this dispensing material comprises a cutout portion with at least 2 dispensing tongues.
Why have you used thermoplastic material?
For reasons like, it reduces the noise levels and also avoids tissue fallback and chaining.
Dr. Shivakumar, I put it to you that the prior art German patent 45678 discloses a tissue box wherein the dispensing insert can be made of paper or plastic.
Yes, German patent discloses dispensing insert which can be made from several materials. And the only example, if you look at in German patent, is disclosing a slit made of paper.
So you are saying that this German patent destroys the novelty of your patent?
No, it doesn't.
But you agree that this German patent does provide an indication to its reader that paper can be placed with plastic?
No. German patent doesn't have the objective to reduce noise levels. It only concentrates on the shape of the dispensing insert, but not on the material of the dispensing insert.
Dr. Shivakumar, but do you agree that paragraph 9 of the German patent discloses that paper and plastic can be interchangeably used?
Yes, it did.
Very well, that answers. Dr. Shivakumar, I put it to you that the US prior art patent 5155211 teaches and discloses the use of thermoplastic materials. Is that correct?
No. The patent discloses coated paper as a dispensing material.
Very well, but do you agree that this coated paper has been used in this patent to reduce noise levels?
Yes, I agree.
Can you please explain, if the coated paper is used in this patent, I think it can be easily replaced with any other material such as thermoplastic material?
Yes, but not for the same purpose.
Can you please explain?
In the sense that the thermoplastic reduces the noise levels to a further level, in the sense to a desired level compared to coated paper.
Dr. Shivakumar, what do you mean by desired levels?
See, for any material which is used in the tissue box, anyone would prefer that the noise levels are reduced to a desired level. So that is what I meant when I said further reducing noise levels. Thermoplastic reduces noise levels compared to coated paper or any other material used in the prior art.
But as a polymer chemist, don't you think it is very obvious to replace the thermoplastic material with coated paper, or coated paper with thermoplastic material to further reduce noise levels?
It was not obvious at the priority date of the suit patent.
Very well. Dr. Shivakumar, kindly refer to paragraph 17 of the US prior art.
Yes.
I note there that it is mentioned that the glossiness of coated paper on at least one side of the paper is important in reduction of noise levels. Do you agree?
So, if you refer our patent, it doesn't discuss about the glossiness of the dispensing insert.
Dr. Shivakumar, you are using polyethylene in your patent.
Yes.
And I assume it is glossy on both the sides.
Yes, well.
Very well.
Everyone knows about that.
Very well. Dr. Shivakumar, I put it to you that your original specification as drafted did not talk about reduction in noise levels, and this problem was formulated only upon prosecution and identification of prior art.
I think you need to refer this specification properly. You please look at paragraph 20 of the US suit patent. It discloses about the noiseless dispensing.
Alright, then let's move a page further. Please refer to the page 3 of this patent.
Okay.
Dr. Shivakumar, I put it to you that this US prior art document has already been identified in the background section of your patent.
Yes, we have identified.
Thank you. So in that case, it's safe to presume that on a combined teaching of this US and German patent, one would arrive at the suit patent.
My Lordship, we have an objection to this particular question. Learned friend is trying to draw legal presumption here, which should not be allowed in cross-examination.
I don't see a harm in this question again. I'll let the court decide on the admissibility, but for time being, I think he can answer. Don't see any issue.
Please,
my Lord. Well, being a technical person, I cannot answer in presumption. But based on my knowledge and experience, what I see is that the combined teaching of D1 and D2 doesn't disclose a dispensing material made of thermoplastic, and this dispensing material having a cutout portion and with at least 2 dispensing tongues.
Dr. Shivakumar, you have also been stressing on 2 dispensing tongues.
Yes.
I put it to you that the number of dispensing tongues cannot be considered as novel or inventive, as it is common general knowledge.
In the suit pattern, at least 2 dispensing tongues are disclosed for the fact that when one tissue is removed, the other tissue is held in an upright position. And in the field of packaging, you must understand that different type of slits play a pivotal role. And I quote again, in the field of packaging.
Very well, that's your field, and I understand. You're obsessed about it. You answered previously that Mr. Robert was leading from the mechanical design department. So you think you're technically qualified to answer this question?
Yes, of course. As a member who worked on the invention, I was very much familiar and guided by the other team members about the dispensing tongues and the packaging.
Very well. Is this your product? The red one?
Yes, it is ours.
Is the other one the defendant's product?
Yes, yeah.
These look very different. Do you agree?
Yes.
Very well. But in your affidavit at page number 3 at paragraph 20, you've mentioned that the defendant's product uses the same material as you are using in your product. Is that correct?
No. What I mentioned is that the defendant's material uses the material as claimed in our patent. You should not compare with the product.
So what exactly is this material you're talking about?
They use nylon.
And how can you say that?
We have tested the material in our lab, as well as we have tested in an independent certified lab. We have submitted the report in the court.
What are you using in your product?
Polyethylene.
Dr. Shivakumar, I put it to you that nylon and polyethylene are completely different materials. Further, your product uses clear polyethylene, whereas my client's product is blue in color. Is that correct?
Yes, but both the materials fall under the category of thermoplastics.
In that case, Dr. Shivakumar, kindly have a look at this slide. Do you agree that polymers can be both thermoplastic or thermosetting? Durkesh, can you move the slide, please? Yeah.
Can you repeat the question?
You agree that polymers can be both thermoplastic and thermosetting?
Yes, well, I agree. Yeah.
And is it possible to convert a thermoplastic polymer into a thermosetting polymer and the reverse process?
Yes, for some special polymers, yes.
Very well. In that case, Dr. Shivakumar, the material used in my client's product can very well be thermosetting.
No. The grade of nylon used by the defendant is indeed thermoplastic.
Dr. Shivakumar, I put it to you that the grades of nylon can very well be thermosetting. Do you agree?
Yes, I agree. Yes.
Thank you. Dr. Shivakumar, I put it to you that the suit patent does not claim nylon to be used as a dispensing insert.
Claim 1 mentions about the term thermoplastic, and nylon is very well covered within thermoplastic.
But in the suit patent, as well as in your product, you are using polyethylene, which I guess works best for the objective of your invention.
Yes, we are using polyethylene, but suit patent doesn't restrict itself to polyethylene. It's just an exemplification given in the specification.
My question is different here, Dr. Shivakumar. My question is to your product. Does it work, the polyethylene works best for the reduction of objective of noise levels?
No, all thermoplastics would work the same way.
How many other materials you've tested?
We have used also polypropylene.
Okay.
Yes.
I put it to you that the use of nylon in the defendant's product is not falling within the scope of the suit patent.
My Lordship, again, my learned friend trying to draw legal presumption here by suggesting that it is not falling and is falling, and trust question should not be allowed.
I think it's a valid question. I think I'll let the court decide, but I think he can answer.
Please, Maharaj.
Please, Maharaj.
Well, I think I have answer that the claim 1 refers to thermoplastic, and thermoplastic covers nylon.
But you keep coming to your suit pattern, but please have a look at the products again. I put it to you that your product consists of 4 oval dispensing tongues, and that works best for avoiding chaining and tissue fallback.
You see, claim of the suit patent covers at least 2 dispensing tongues without any limitation to shape, as you are referring to.
But my question again is to your product, Dr. Shivakumar. Does it contain 4 dispensing tongues?
Yes, well, the product covers 4.
Thank you. Let's look at the suit patent. Please read paragraph 18 of the specification. Do you agree that it says in a preferred embodiment where there are 4 oval dispensing tongues, this particular shape has proved high efficiency in avoiding tissue fallback and chaining?
Dr. Shivkumar, you are requested to answer directly and not look at your counsel for help, please.
Thank you, my lordship.
I think I have to repeat the answers for, I think this answer is same for all the questions, what you are asking. The claim of the suit patent covers at least 2 dispensing tongues.
Thank you for repeating this again, but my question is different again, Dr. Shivakumar. Let me simplify. Is your product disclosed as a preferred embodiment in your patent?
Yes.
Thank you. That answers. I put it to you that the export affidavit of Dr. Bhatt relied upon you has been prepared under the instructions of the plaintiff.
Yes, it is.
So that means you provided your in-house results to Dr. Bhatt to prepare his affidavit.
No, I have to deny the suggestion.
Dr. Shivakumar, I put it to you that your testimony, including your affidavit, is biased, argumentative and false.
No, I deny the suggestion.
Thank you. That's all from my side.
Thank you.
Very well, thank you. So now that we have heard the defendant's side, can we have the plaintiff's counsel for the cross-examination of the...
Good evening, Dr. Bola.
Good evening.
Hope you are doing good.
I am. Thank you.
Great to know that. Okay. Please refer to the affidavit. Can you identify your signature?
Yes, I can identify my signatures. I have signed on all these pages as a deponent.
Okay. I put it to you that you are not aware of the contents of the affidavit filed by you before this honorable court.
I am fully aware of what is stated in this affidavit.
Okay. What is your educational qualification, Dr. Bola?
So see, I did my, BTech in the area of chemical engineering. Thereafter did my master's in the area of plastic packaging. And thereafter I did my doctorate in the area of polymer sciences.
Okay. How long have you been associated with your own company?
So, of course, as I said, this is my own company. I set up this company in 2016 along with the co-founder.
Okay. What is your role in your own company?
See, if you look at my CV, which I have given along with the affidavit, it provides all the information that you're looking for.
Okay.
I'm a co-founder and a director in this company.
Okay. And prior to your association with your own company, in what all fields you worked with?
So I've been around in this plastic packaging industry for a while. It's been almost 30 years now.
Dr. Bola, I would like you to be specific in your answers.
See, I started off my career teaching at Manipal University for about 5 years.
Okay.
Thereafter, for about 10 years, I was a product consultant in the plastic packaging industry. And then another 15 years or so as a global vice president, plastic packaging, in a very large size company. So I've been around for a while.
Very well. I must say, it's a long journey from being academician to director of your own company.
I object, my lordship. This question is presumptive in nature. It's beyond the affidavit.
I tend to agree. Can you please reframe your question?
Please,
Very well. Dr. Bola, what managerial stakes do you have in your own company?
So I have this 50-50 partnership with my co-founder.
But you just mentioned it's a company. How you can have a partnership?
I mean, so what I meant was that me and my co-founder have got equal number of shares in this company.
Okay. Are you in a position to explain the incorporation details and article of association and share pattern of your own company?
I mean, I'm surprised all the documents that you're asking for are sitting along with my affidavit. I mean, it has got the original certificate of incorporation, articles of association of the company. All that is sitting there. Why don't you have a look at
Well, Dr. Bola, you have all the right to be surprised, but this is the court process. Documentary evidence has to be substantial, the oral testimony. We can't help it. Okay. Moving ahead, if I may presume by your own documents, you are not aware of the contents of the documents mentioned by you regarding article of association. Would that be correct to presume?
So see, I'm aware of what is sitting there, but of course, a lot of these are legal documents. So I'm sure my consultants would have helped me in this.
Okay. Kindly refer to your CV. It suggests that you don't have any technical qualification only to read and understand the contents legal documents. You only claim your technical expertise only.
Look, that's the reason I said that we hired a chartered accountant to do all that paperwork, be it in terms of incorporation of company, articles of association.
Okay.
You already answered the question.
But it's nothing sitting in your affidavit, that's why. Can you substantiate this, your question with any document?
So I must be having a few emails sitting with me where I instructed my chartered accountant for that work, so I can always produce that in the next hearing.
Very well. Any idea when you instructed?
Sometime in 2016.
Again, Dr. Bola, please be specific in your answers.
I think it was around May 2016.
Okay. Kindly refer to your CV. It suggests that you were the Vice President of Global Product Development, Plastic Packaging from 8 to 16.
Yeah.
Would it be correct to presume that while working with XYZ company, you instructed your CA to incorporate your own company, the present company?
That's correct. I was part of that company when
But I believe you must be aware of the global employment laws. While working with your own company, you cannot work for another company at the same time.
See, I'm very clear on this. When I instructed my CA to set up the company, I did that in my individual capacity, not as an employee with my previous organization. And as you can see from the records that I have already submitted, the company got incorporated only in the month of November 2016.
Okay.
October 2016, right? And by the time when the company was incorporated, I was already out of my previous organization.
So you are suggesting that you are working with XYZ till August 16, you instructed your CA in May 16, and you got your company incorporated in November 16.
That's right, you're right.
Okay. Where was your co-founder working that point of time?
So my co-founder was working as a director in another company, and he had quit that company around August 2016.
So you both decided to quit your current jobs and then incorporate this company?
Yes, you're right.
Okay. So you both must be in the planning phase from May 16 when you first instructed your CA?
Not really. See, I mean, strategizing, setting up a company, doing whole lot of planning takes quite a bit of time. It doesn't happen overnight.
Would that be safe to presume around 1 would be sufficient? 1 year would be sufficient?
I mean, it could be even more than that.
Okay. Going ahead. What is the core business area of your company?
So see, we are a manufacturer of, high quality craft paper, corrugated rolls, printed boxes and things like that.
And your company launched the entire range of product in one shot or in a phased manner?
No. We started off small with this tissue boxes, and then gradually we added more products to our product line.
How long has your company been in the market then?
We've been in the market from November 2016.
Okay. And what is its market share of your company in the sales of your product? This one, wipes?
See, today I must admit that whatever we are as a company today is essentially because of our first blockbuster tissue box product.
So you claim this product as a blockbuster product?
It is indeed. I mean, everybody knows that.
Very well. Since when is your company engaged in the manufacturing of wipes?
So we started doing that from the very beginning we were formed.
From November 16, right?
Right.
Okay. Please refer to para 13 of your affidavit. You stated that you have incorporated your company with a bare minimal capital of 5 lakhs. Would that be correct?
I mean, for you it might be a bare capital, but for a young company like us, at that point in time, it was not.
I apologize for hurting your sentiments here. Let me reframe my question here. Kindly refer to the sales figure of your own company. Your turnover has increased drastically since the time of its incorporation.
Yes, I think we did reasonably well, from the very beginning.
Okay. In that case, kindly refer to your own documents, annual report submitted by you. Please let me know whether the figures mentioned as annual turnover is a cumulative number of all the entire range or only related to this particular product wipes.
So our annual report reflects the annual turnover for the entire company, including this product, but not limiting to this product.
Can you bifurcate the numbers because of this product and the entire turnover?
So see, by looking at the annual turnover, you can't really make out how much contribution came in from this product. What I've already mentioned is that the total number is for the entire spectrum of products, but this product contributed significantly to our own annual turnover. And you can always refer to the CA report to get more information on what you're looking for.
Very well, I can always refer. That's why I'm not referring. Please refer. Kindly you only refer right now.
Okay.
Kindly refer to CA certificate. It is safe to presume here that the product in question, wipes, contributes to the major chunk of your annual turnover. Would that be correct?
Yes.
Okay. Approximate cost of manufacturing?
So it costs us around 40 to 45 rupees to make one box.
And in the market?
We sell it at 100.
Okay, and your annual report suggests that your annual turnover for 17-18 was INR 5 crores.
Yes, we did that much in that year. Yes, you're right.
Pretty impressive figures.
Thank you.
Please refer to CA certificate. It suggests that you have sold around 750 units of wipes in 17-18.
You're right. Yeah, we sold that many.
And you earlier stated their manufacturing costs are around 40 to 45.
Yes.
So, in that case, I can safely presume that 750,000 multiplied by 40 to 45 would be around 3 crores of your annual turnover.
I mean, you can presume that, but I don't think your numbers are correct. I've already told you that cost us 40 to 45 rupees to make that one box. The rest of the information that you are looking for, you might find in the CA certificate, but I totally deny the suggestion you're making.
Dr. Bola, I simply asked you, it is safe to presume that the product in question contributed, and I quote, around INR 3 crores in the annual turnover. I'm not asking for a specific number here.
You're free to presume whatever you may want to. I've already answered your question.
Very well. Are you suggesting that annual turnover as submitted by you is only because of the product in question?
No, I have already said that it's essentially a accumulation of all the revenue we made through entire spectrum of product. But as I said earlier, this one contributes significantly to the annual turnover.
Okay. Based upon your position, you must be in access to key decision-making capacity of your company. Can you tell us about the development of the product in question, wipes?
Yeah, so we started making this product from the very beginning.
So, like, when was it developed and launched?
So see, we developed this, me and my co-founder, together we developed this product. We developed it around sometime in 2016 and then launched in November 2016, yeah.
You developed in October 16 and launched along with the incorporation in November 16?
Yes.
Very well, that answers my question. Do you consider the product to be novel and patentable?
Absolutely, I think it's novel and pretty unique.
Then why did not you file a patent application for this?
I mean, see, you need to understand. So we were a young company in 2016. We were focused towards releasing our product. Patenting was not considered at that point in time.
Okay. So I understood your concern. You already mentioned that bare minimal capital.
But I'm still wondering why you ask the same question again and again.
Let me ask the questions. Court will decide regarding the admissibility and the importance of these questions. Okay, very well. Have you come across plaintiff's product? This one.
Yeah, they're generally well known in the market, yeah.
They are generally well known, meaning thereby you are suggesting that plaintiff's product are well known in the market.
I didn't say that.
Okay.
I didn't say that.
Do you know about the plaintiff's company?
Yeah, I know, they've sued us.
Obviously. Now you know. And you're suggesting that you never came across plaintiff's product.
I mean, they're generally known in the market.
You're generally known in the
market.
Are you aware of the suit patent for which you have been sued for?
Yeah, I'm aware of it and I think it's been wrongly granted.
That must be a presumption. I suggest that, as a counterblast, you only file this counterclaim to challenge this patent.
I deny the suggestion, not at all.
So why did not challenge the patent when it was granted earlier? Why you were waiting for getting sued?
I mean, so it was a management decision at that point in time not to go after this patent. It's as simple as that.
Management decision.
Absolutely.
Perfect. So it is safe to presume that you were aware of the plaintiff's product as well as the patent for the same.
I mean, the number is sitting on that box.
That's our concern, and we have to mention that. It will always be sitting on the box, any which ways. So you were not aware of suit patent before launching your product? You were not aware?
Yes, I was.
You were completely not aware?
Absolutely.
You only got aware when you got sued?
Absolutely.
Perfectly fine. That answers my question. And please refer to your affidavit. Paragraph 12 to be a bit more specific. You stated that German patent 45678 and US patent 5155211 destroys the novelty and inventive step of the suit patent.
Oh, absolutely. Totally. Absolutely.
Have you read and understood both the prior arts?
Yes, of course. That's the reason I'm saying.
Meaning thereby you are aware of the patents laws as well.
See, I'm answering your question based on my technical expertise. All I'm saying is I can read the German and the US patent and I understand what is sitting there.
Okay, by reading based upon your technical understanding, I put it to you that German patent discloses and exemplifies a dispensing insert made up of paper.
Yes, it does, but at the same time, if you read that patent, it also discloses a dispensing insert made up of plastic.
Very well.
Yeah.
I put it to you that US prior art does not disclose a dispensing insert made up of thermoplastic material. Do you agree?
Yes, I agree.
You agree for that?
Yeah.
Okay. What is the dispensing insert disclosed in US prior art?
The US patent discloses coated paper as the material for the dispensing insert.
Coated material.
That's right.
Very well.
Yeah.
Okay. So you are saying that none of these documents discloses a dispensing insert made up of thermoplastic material.
Dr. Bhola, can you please answer directly, not to look at your counsel?
Okay.
Please, my lordship.
Okay. See, I totally deny the suggestion. See, if you look at the German patent, the para 9 in the German patent discloses dispensing insert made up of various materials, including plastic. Now, if you look at the US patent, it discloses dispensing insert made up of coated paper, essentially to reduce the noise level.
Very well.
So, all that the plaintiff's patent has done is that replace that coated paper with another kind of a material, polyplastic, thermoplastic material like polyethylene, essentially to reduce the noise. So it's a pretty obvious replacement of one kind of material with another known kind of material.
Okay, and all this of novelty, obviousness concept you are suggesting and explaining here is based upon your only technical expertise.
Yes, of course.
Okay, very well, that answers the question. So based on the answers, I believe that you are aware how to read and understand patented document.
I think I already answered that question multiple times. I just don't understand why you're asking the same question again and again.
Okay, in that case, you can understand the claim 1 of suit patent with disclosure dispensing insert comprising a cutout portion with at least 2 portions that contact the border of box opening. Do you agree?
Yes.
Okay. I put it to you that you said claimed feature is not disclosed in any of the cited prior arts.
Sorry, I didn't get the question. Can you come again, please?
I put it to you that said claimed feature, that is claim 1, is not disclosed in any of the cited documents.
No, I deny the suggestion.
Who drafted this counterclaim for you?
My lawyer did it under my instruction.
So you are aware of the common general knowledge, because right now in the previous answer you gave a brief description of common general knowledge.
Yes, I do.
Why don't you explain then?
I object, my lordship. The witness cannot answer a legal query.
I agree, it's a question of law. Can you
Please,
go
my
forward?
lordship.
Very well. Is this your product?
Yes, this is my product.
And this is our client's product?
Yes.
And they look very similar.
Not at all, they're very different.
Oh,
I mean, anyone
great.
can make out, they're very different.
Great. In your affidavit at para 21, you mentioned that your product uses nylon. Is that correct?
Yes, we use nylon.
Okay. And what is plaintiff using in their product?
They claim they are using poly.
They claim they are using
They
poly.
claim they are using, I don't know what it is, but they claim, yeah.
Oh, very well. I put it to you, kindly refer to the slide, that nylon and polyethylene are similar and both fall under thermoplastic category of materials. Is that correct?
No, that's not the case. See, if you look at it, all polymers have 2 kinds of properties.
Okay.
Thermoplastic or thermosetting.
Okay.
Depending upon the temperature and grade and things like that. So the polyethylene they are using, whether it's thermoplastic or not, I have no idea.
But you suggest that they will vary based upon grades,
Absolutely,
temperature.
absolutely. I mean, everyone knows that.
That's fantastic, including you, definitely. I put it to you that nylon used by in your product is thermoplastic.
No, totally deny the suggestion, not at all.
Okay, what according to a thermoplastic material then?
So when you look at thermoplastic, thermoplastic is basically a polymer,
Okay.
which is moldable above a certain temperature, and it solidifies upon cooling. So that's what thermoplastic material is all about.
That's all.
Yeah.
Okay. Please see the products again. I put it to you that product consists of 2 rectangular dispensing tongues which falls within the suit patent. That's the same infringing. This.
No, not at all.
Okay. In that case, I put it to you that testimony, oral as well as documentary, whatever you submitted, is not only biased but false, argumentative and frivolous.
Totally deny the suggestion.
Very well. That's all from my side.
Thank you to both the counsels. Now that the cross-examination is over, I will pass the files back to the High Court for further proceedings. Trying to impose their position on this case and influence the judgment in their favor. So let's take you to the final day of the final arguments.
My lordship, on issue number 1, we submitted in the last hearing that there is no jurisdiction, and we substantiated how the district court did not have any jurisdiction to try the present suit. Coming to issue number 3, which is the counterclaim and revocation challenge, my lordship, we submitted our submissions on how the patent of the plaintiff has been obtained on a false suggestion and misrepresentation. The product claimed in this patent has been publicly used in India much before the priority date, and thus it's not new. My Lordship, there is no proper exemplification in the specification of the suit patent, and the patentee for the patent has also failed to disclose the corresponding foreign application details. My Lordship, today I will discuss in detail about the lack of inventive step in the suit patent. My Lordship, the suit patent IN 12346 relates to a tissue box comprising 4 dispensing tongues and a dispensing insert made of a polyethylene, a thermoplastic material. My Lordship, as submitted before, plastics have been used as dispensing insert much before the priority date and have been available in the market before this patent. My Lordship, we challenge the inventive step of this patent on 2 prior art documents, the German prior art and the US prior art. My Lordship, the US patent 5155211 discloses a tissue box wherein the dispensing insert is made of coated paper, whereas the German prior art discloses a dispensing insert made of paper or plastic. My Lordship, we refer to example 1 of the US prior art, and from this example and the analysis of the whole specification, it is clear that coated paper, when used as a dispensing insert, reduces the noise levels while tissue dispensing. My Lordship, this has also been admitted by plaintiff's witness, Dr. Shivakumar, in his cross-examination. Further, this patent also discloses that the glossiness of paper on at least one side is helpful in reduction in noise levels. My Lordship, after knowing the nature of the art, the plaintiffs have just done mere trial and error to replace plastics with thermoplastic. My Lordship, this replacement of plastic with thermoplastic, which is also a category, which also falls in the category of plastic, is a mere workshop improvement. My Lordship, also the complete specification of the suit patent is completely silent on how this substitution has been arrived. Further, there is no comparative data whatsoever in the specification of the suit patent wherein it shows that the thermoplastic material reduces noise to a greater extent than the coated paper. Further, my Lordship, this US prior art is also an admitted prior art in the US in the suit patent, and one of the inventors, Mr. Jeff, is common amongst these patents. My Lordship, this simply implies that Mr. Jeff was already aware that glossiness of paper, increase in glossiness of paper is going to reduce the noise levels to a greater extent, and thus he made the trials with polyethylene, which is obviously glossy on both the sides. My Lordship, we also place reliance on documents D3 to D8 to show that substitution of plastic with thermoplastic materials is not uncommon in the field of experimentation. My Lordship, we have also filed evidence by way of affidavit of Dr. Bhola, wherein he deposes as to how these 2 prior art patents, how an inventor would arrive at the suit patent starting from these prior arts. My Lordship, we therefore submit that the suit patent is not only liable to be revoked on the ground of lack of inventive step, but also for insufficient description, prior public use, and non-compliance of Section 8. Coming to the issue number 4, that is the issue of infringement. My Lordship, my client's product, wipes, has a dispensing insert made of nylon, which is neither claimed, disclosed, or enabled in the suit patent. Further, my client's product has 2 rectangular dispensing tongues, which is again neither disclosed, claimed, or enabled in the suit patent. My Lordship, the plaintiffs have been vehemently trying to establish that polyethylene and nylon are similar materials. But my Lordship, we have to understand that the properties of polymers can be poles apart, and this has also been confirmed by Dr. Shivakumar in his cross-examination. My Lordship, the tests submitted in the expert affidavit of Dr. Bhatt by the plaintiffs are unreliable and unjustified experimental methods. Thus, it cannot be taken on record that the grade of nylon which is used in my client's product is thermoplastic. My Lordship, the specification of the suit patent as well as Dr. Shivakumar's cross-examination clearly establishes that the four oval dispensing tongues as well as the polyethylene material works best for the objective of their invention, that is reduction in noise levels and prevention of tissue fallback and chaining. My Lordship, therefore, the defendant's product consisting of two rectangular dispensing tongues and made out of nylon is clearly not infringing on the suit patent. Regarding issue number 5, my Lordship, it has been established that the suit patent is not valid and my client's product is not at all infringing on the suit patent, thus this issue should be decided against the plaintiff. That's all from my side, my Lordship.
My Lordship, on the previous day of argument, we have submitted how this court has jurisdiction to try this particular suit, and we have categorically established by certain amount of case laws as well as the invoices produced, and stating thereby this issue should be decided in favor of the plaintiff and against the defendant. Regarding issue number 2, regarding the validity of suit patent, my Lordship, we have already produced the legal proceeding certificate and thus we have discharged our burden. My Lordship, coming directly to issue number 3, which is the most contentious issue here. My Lordship, the entire issue number 3 has been crafted, argued and submitted before this honorable court by a reading of a wrong interpretation of a claim. My Lordship, I like to produce before this honorable court a judgment by Delhi High Court which suggests how to read a claim, the laws of claim construction. My Lordship, the defendant, as my learned friend, is reading the claim as IN 123456 relate to a tissue box comprising a dispensing insert made out of polyethylene, a thermoplastic material and 4 dispensing tongues. My Lordship, just referred to the granted patent and claim number 1. There is no iota of suggestion that the claim should be read like this. Claim 1 reads, a tissue box disclosing a dispensing insert made up of thermoplastic material comprising a cutout portion with at least 2 portions contacting the border of tissue opening. There is no limitation of putting polyethylene and 4 dispensing tongue within the limitation of claim 1, my Lordship. Thus the whole argument and the whole submissions as a whole counterclaim is based on fallacious interpretation of claim 1, my Lordship. My Lordship, they have referred to 2 prior arts, US patent as well as German prior art. They are suggesting that US patent uses a coated paper at dispensing insert, whereas German patent discloses a dispensing insert made up of paper, my Lordship. My Lordship, much emphasis have been given on the gender disclosure in German patent. German patent 45678 claims a dispensing insert made up of paper. However, generally discloses a dispensing insert can also be made of plastic. My Lordship, I would like to produce before this honorable board a judgment by House of Lords which suggests a prior art has to be enabled at the time of utilizing the same for the purpose of determining obviousness. Thus the whole argument as devised that German patent 45678 also discloses a dispensing insert made up of plastic is completely false and frivolous. My Lordship, at this point of time, I would like to reiterate the novel features of 1, 2, 3, 4, 5, 6. Reducing noise level when you take out the tissue from here, as well as preventing tissue fallback and chaining, so that earlier the tissues could be used out, however a couple of tissues got attached to it. That is the inventive and novel feature here. Reduction in noise level as well as preventing falling chain back. None of the prior arts, my Lordship, none of the prior arts have been disclosing anything, any novelty feature. There is no teaching suggestion or motivation towards the same. My Lordship, they are again referring to documents D3 to D8 to suggest that it was a common general knowledge that disclosure to displace material plastic with thermoplastic. My Lordship, with all humble submission, neither they have produced such documents, and whatever documents they have produced do not relate to the same field. neither their allegedly witness have stated that he is aware of common general knowledge at all. When a particular question was put to him, he simply denied he is generally aware of common general knowledge based upon his mere technical expertise. However, the law says common general knowledge as a date of priority, not subsequent technical expertise of any expert witness. My Lordship, one contention was there. No comparative data has been produced by the plaintiff. However, my Lordship, at page 20 of the suit patent, a comparative data has been provided of further reduction of noise level from the prior art US 5155211. My Lordship, another fallacious argument has been taken that glossiness of thermoplastic material as contended by defendant show glossiness, like coated paper has been considered as glossy. That's why there is a teaching suggestion that a thermoplastic can be used which is clearer in nature. My Lordship, this totally suggests the wrong understanding. The claim 1 is only limited to thermoplastic material and at least 2 dispensing tongue. Nothing regarding has been mentioned about glossiness, polyethylene, nylon, nothing has been mentioned, my Lordship. Further, one of the contention has been stated that Mr. Jeff is a common inventor. With all due humble submission, my Lordship, the grounds as mentioned 64 is exclusive in nature. There are only 17 grounds, and being a common inventor in a 2 subsequent patent is not a ground to challenge the validity of a patent. My Lordship, again, on the enablement, it has been categorically stated that the suit patent is not enabled at all because there are only 2 examples of polyethylene polypropylene. However, my Lordship, these are 2 representative examples and laws regarding this are very much settled. Once a general disclosure as per section 10.4 has been given and suggests the best method of working, the same can be taken as well enabled at the same point of time. My Lordship, another section 8 compliance has been taken, and in all humble submission there is no material concealment has been there, and thus they fail to discharge their burden. Coming straight over to issue number 4, my Lordship, regarding infringement. Again, my Lordship, I suggest that it's a fallacious approach has been taken by comparing the products versus product, whereas the law is well settled of comparing claim versus product. Defendants were trying to create a hypothetical distinction here of nylon to be either thermoplastic or thermosetting. However, the grade of nylon, which has been tested by in-house labs, has been considered thermoplastic by our, and same has been substantiated by in-house labs as well as an independent expert, Dr. Bhatt. My Lordship, one further approach has been taken by the defendant of trying to compare the enablement regarding especially the dispensing tongue with the infringing product, meaning thereby you have enabled only one kind of product specification, that's why same is not infringing. Which is again, my Lordship, going beyond the mandate of law, whereas the granted patent has to be compared with the infringing product, not an enabled example has to be compared. My Lordship, the plaintiff has discharged his burden of infringement by substantiating the same with the help of an in-house report as well as neutral expert, whereas defendant have drastically failed to discharge their burden by not substantiating their arguments or contentions of non-infringement at all. My Lordship, Dr. Bola in his cross-examination has also suggested the same. He has failed to prove that grade of nylon used as an insert in the product is not a thermoplastic. That's what their contention. On the contrary, Dr. Bola in his cross-examination has admitted a polymer can be either thermoplastic or thermosetting based upon the grades. Nothing has been given that this grade of nylon is falling, whereas plaintiff has discharged their burden. This particular grade of nylon is very well falling in the category of thermoplastic. That's why this particular patent is getting infringed. In all humble submission, my Lordship, this issue should be decided in favor of the plaintiff and against the defendant. Coming to issue number 5, my Lordship, regarding damages. My Lordship, one more thing here. In the entire chain of cross-examination, defendants have categorically stated their intention to incorporate, meaning thereby from October 16 they took the approval, November 16 they got the company incorporated, and thereby instructing the CA in May 16 and launching the product. The timelines are getting matched with the loss in sale of our own product. Now, coming back to issue number 5, my Lordship, we have already produced our sales figure to substantiate the loss in sales what we have incurred so far, as well as in order to further substantiate, we have also furnished one evidence by Dr. Manish, our Chief Financial Officer. showcasing continuous loss suffered by the plaintiff due to the presence of infringing product, my lordship. In all humble submission, my lordship, this issue should be decided in favor of the plaintiff and against the defendant. That's all from my lordship.
The counsels for the plaintiff and defendant have concluded their argument on all the issues. Having heard both the plaintiff and the defendant, I proceed in deciding as follows. With regard to issue number 1, which reads as whether this court has jurisdiction to entertain the present suit, on a perusal of all the materials placed on record by the plaintiff, which includes original invoices showcasing the procurement of the infringing products within the territorial jurisdiction of this court, I hold that this court has the jurisdiction to entertain the present suit. Thus, this issue is decided in favor of the plaintiff and against the defendant. Issue 2, which reads as whether the plaintiff is the owner of the suit patent bearing number 123456. On a careful scrutiny of the legal proceeding certificate as obtained by the plaintiff from the IPO, it established that the plaintiff is the patentee in the patent bearing number 123456. Thus, this issue is decided in favor of the plaintiff and against the defendant. Issue 3, which reads as whether the suit patent number 123456 is valid. I have heard the plaintiff as well as the defendant on this issue. While the defendant bases its argument of invalidity of patent on a number of grounds under Section 64 of the Patents Act 1970, their primary argument is based on Section 64(1)(c), Section 64(1)(e), 64(1)(h), 64(1)(j), 64(1)(f), and 64(1)(m). After hearing both the plaintiff and the defendant on this issue, I hold that the defendant has failed to discharge its onus to substantiate that suit patent is wrongfully obtained. The suit patent is novel as the claimed feature has not been disclosed in either of the prior art cited. The suit patent is not obvious for the following reasons. Tissue box comprising a dispensing insert made of thermoplastic made of at least 2 dispensing tongues cannot be arrived by combined teaching of patent US 515521 and DE 45678. The technical advancement in the suit patent lies in reduction of noise levels and to avoid tissue fall and chaining. None of the prior arts provide any teaching or suggestion or motivation towards the same. The comparative data as submitted by the plaintiff is clear enough to understand that the suit patent covers reduction in noise levels as compared to prior arts, including that of coated paper disclosed in US 5155211. As regards common general knowledge, the defendant has failed to produce any document or oral testimony to demonstrate what was common general knowledge at the time of priority date of suit patent for replacing plastic. I further hold that the suit patent is sufficiently enabled by way of exemplification in the specification as example 1 discloses polyethylene and example 2 discloses polypropylene. The defendant has failed to discharge its onus to substantiate that the suit patent was obtained on a false suggestion or representation. Since non-disclosure of prosecution details of the corresponding applications was not material to the grant of suit patent, thus said ground is not valid. Thus, this issue is decided in favor of the plaintiff and against the defendant. Issue 4, which reads as whether the defendant are infringing the suit patent. Upon hearing the contention of both the plaintiff and the defendant, I am of the view that the defendant has taken a fallacious approach by comparing products of the parties as a settled position of law dictate that the right approach of comparison in case of patent infringement is claim versus product. I am further of the view that the plaintiff has also discharged its burden by producing before this court an in-house report as well as affidavit of one Mr. Bhatt, whereas the defendant has failed to discharge their burden by not filing any report substantiating non-infringement. Thus, this issue is decided in favor of the plaintiff and against the defendant. Issue 4, which concerns damages, I hold that the plaintiff has submitted before this court that it has been suffering losses in sales due to the presence of infringing products in the market. It has also produced evidence by one Mr. Manish, CFO, substantiating losses by the plaintiff. At this point of time, I direct the defendant to produce its statement of accounts before this honorable court so that this court shall determine the quantum of actual damages. In the interim, this court awards ₹5 lakh to the plaintiff as cost. Both the parties to lead evidence for issue number 5, written orders to follow soon.
Please, my lordship.
So there we go. So we heard the judgment from the Honorable High Court deciding the case in favor of the plaintiff. And that's all we have. We are running out of time, but this is a quick summary of what we saw today. We are open to questions. Any questions? Yes, Bart. Can you have the mic, please?
Yes, thank you for this nice presentation of this court case. It's very interesting. One thing I was puzzling out, you have developed quite a lot of issues about the fact that the infringing product would resemble the product of the plaintiff. And I only heard in the last final arguments that indeed it doesn't really is about the likeness of the products, but it is whether the infringing product falls within the claims, yes or no. My question is now, would things have been developed differently if there would have been no product of the plaintiff at all, but only a patent?
Very well. In this case, the question which generally court asks, whether your own product is falling within your own suit patent. So the things have developed in India, and where the courts have now only started to look at granted claims with the infringing product. That is the only reason we suggest to file an expert witness to suggest that how the characteristic feature of infringing product is falling within the scope of the suit patent. Nevertheless, the courts do consider, in like for example in simple mechanical cases, they do considering the product of the plaintiff as well, just for the sake of convenience and reference, but not for the final adjudication of the suit.
Any other? Just
one.
So you are saying if the plaintiff did not have the product, the judgment and everything would have been the same.
Very well, that's the law.
I just have one question from the perspective of claim interpretation, because here a claim was interpreted. So in case of a claim where one of the features in the claim is qualified by the term optional, which is not a regular practice, but there has been some applications or granted patents in past where one of the elements was qualified with the term optional. And correspondingly, when you look at the specification, in order to interpret the claim, because of the inherent ambiguity in the claim itself,
right,
and if you find in the specification that there is no single example,
okay,
which is without that optional feature. So every example is basically demonstrating certain results with that optional feature. So can that claim be interpreted as, can that optional feature be actually interpreted as optional, or it can be questioned on the ground of insufficiency of disclosure?
Very well. The law has been developed in India. It primarily starts with the simple strict reading of the claims as such. Now, if there is a ambiguity in the claim, like in this particular example is optional, the courts will look back into the specification for the intention to include that particular word. It is not like that it is always the words which have been used, it will be used. The courts do have stated and do have referred to the specification to understand why that particular thing has been inserted. Say for example, there is no enablement given in the specification at all. At that point of time, now the plaintiff has to choose whether that particular terminology present in that particular claim is required or not. In one of the cases in India, the same has happened, and the plaintiff understood and found out that this particular optional feature is not enabled in the specification, that's why that's not required at all. So they invoked section 58 of the Patents Act and they moved ahead for amendment of claim before the High Court. So that's how one has to understand why the terms have been used. The courts will look into the specification, intention behind using those terms. If plaintiff itself is coming to the understanding that it has wrongly been used for some prosecution details or like whatsoever, then they have an option to further amend it before the High Court as well.
Okay, so I just one last question from my side. If for this particular example, if you look at the prosecution which has happened in other countries, and if suppose the claim has been granted there as where the third element which was optional in India, there it has been granted as an essential element. The claim has that as an essential element because it was in coincidence with what was exemplified. So will that fact have any impact on interpretation here?
No. In India, the prosecution history estoppel is not established like US. So whatever has happened in US or say for example Europe will not hold binding on the Indian courts to understand that. Although the courts are referring to as persuasive value and it's a matter of defense, but that as suggested, the prosecution history estoppel will not be binding here.
Thank you.
Also during prosecution, not at the litigation stage, but even before that at the prosecution, although not binding, but the examiners are increasingly relying on what has been granted in other countries. So during prosecution, if let's say for example this was an optional term and if it has been limited in other countries, the examiners in India will be influenced to request the applicant to bring in that term as a mandatory feature in the claim. So there is a lot of reliance on what is going on in prosecution, during prosecution in other countries, especially Europe. But of course, as I said, it's not binding. It can depend on case-to-case basis and on the examiner. But on an average, we are seeing, very heavy reliance on granted claims in US, Europe, some of these IP-savvy jurisdictions.
Okay, yeah. Thank you.
So if we don't have any further questions, we from K&S would like to thank you for taking out the time and being here. We enjoyed bringing this to you and hope you found it useful. Thank you very much.
Thanks a lot.
Thank you, sir.
Your voice is very strong.
So my request to all of you to remain present during that the APC award ceremony. Yeah, 7. Yeah.